Now let's listen.
On the state's motion to compel answers from deponents Zachary Cruz and Richard Moore, who's going to be arguing for the state?
I will, Your Honor.
Okay, and is Mr. Zachary Cruz and Mr. Richard Moore present?
Good morning, Your Honor. My name is Amina Matheny-Willard. I am the attorney for Zachary Cruz and Richard Moore. Richard Moore is here today, but we're here prepared to argue that motion. And this is David Reiner.
Good morning, Your Honor. David Reiner, local counsel.
Okay, come on up.
Would you like us to come to the podium?
Well, there's not really anywhere else to come to. If you want to, you can sit in the jury box if you'd be more comfortable.
Which way, Your Honor?
Or you can stand there, or you can. We're sort of just set up for two sides here. Okay, Mr. Klinger.
Good morning, Your Honor.
Good morning.
The state took the depositions of Zachary Cruz and Richard Moore. They were taken at separate times, about 7 weeks apart. At the first deposition of Mr. Cruz, Ms. Willard made many objections as to relevance. There was a discussion of the law in the state of Florida on relevance and how it's handled in a deposition. And the questions are to be answered then later on when the deposition or any parts that are going to be put into evidence in the trial court can rule on whether the objections made by counsel were appropriate. However, Ms. Willard continued to not only object, but she instructed her client not to answer numerous questions during the deposition. 7 weeks went by, and then there was the deposition of Richard Moore. Again, Ms. Willard was representing Mr. Moore, and the exact same thing happened. The state, once again, outlined the law in the state of Florida. The questions must be answered. The case law is very clear on that point. But once again, there were objections to relevance, and the witness was instructed not to answer the questions. So at this point today, we ask this court to grant the state's motion to compel. The law in the state of Florida is clear. One must answer questions at deposition unless there's privilege or unless the party had come to the court before that and asked for the deposition to be limited in some fashion. In this case, neither of that happened, and there is no reason why both deponents should not be compelled to answer the questions. When it comes to whether or not they're used at trial, then this court can make a decision as to the question.
Let me just call on.
Okay.
What I would ask the court to consider on the state's motion to compel, page 9, it references Florida Rule of Civil Procedure 1-310, subsection C, which indicates at any time during the taking of the deposition on motion of a party or of the deponent and on showing that the examination is being conducted in bad faith or in such manner as unreasonably to annoy, embarrass, or oppress the deponent or party, or that objection and instruction to a deponent made not to answer or being in violation of Rule 1.310, subsection C. What I'm asking the court to do is use that Florida Rule of Civil Procedure. I'd like to provide the court with a timeline so that the court understands that this deposition was not taken in a vacuum. So I think providing the court some context would be useful in this situation. Around November, and this is in reference to our response with regard to how Zachary Cruz has been treated as a result of.
I'm sorry, Mister. Give me just 1 second. It's echoing. Do you hear that?
Did we
echo?
move back?
No, we just need to fix it on our end. Okay, should be better now.
Okay. So I'm providing this again to put this in context of what Zachary Cruz has gone through since this occurred, along with Richard Moore. So November 1, 2017 was the death of Linda Cruz, the mother of Zachary Cruz and Nikolas Cruz. On November 1st, 2017, the date of their mother's death, Zachary went to live with members of the family. On February 14th, 2018, was the shooting that brought us here today. On March 19th, 2018, Zachary Cruz was arrested for trespass here in Broward County, and he was placed on a $500,000 bond. On May 3rd, 2018, Zachary Cruz announced that he was filing litigation against Broward County for false arrest and torture. On May 12th, 2018, the judge allowed Zachary Cruz to move to Virginia, where he is currently residing with Richard Moore and his family. On May 13, 2018, Zachary moved to Virginia. From June 2018 through the present, Zachary Cruz has been harassed and intimidated by Augusta County Adult Protective Services and the Augusta County Sheriff in Virginia. There was a local...
Counsel, I'm sorry to interrupt. I'm very familiar with the timeline. I know the facts of the case. I've read the deposition. What is or is not happening in Virginia? I don't know how that relates to his deposition here in Broward County related to an incident that happened in 2018 and the facts surrounding that incident.
Your Honor, and I'll just provide the court with a summary. Basically, what is happening in Augusta County, there is coordination between Augusta County Sheriff and Broward County Sheriff. Zachary was pulled into a grand jury in the Western District of Virginia, and he was questioned about the Parkland shooting case. So we believe that there's coordination. I'm asking the court to understand that there has been consistent coordination and harassment. So we are very concerned about questions that, one of the questions is where Mike Donovan and Richard Moore were married. That's totally irrelevant. They have answered questions that are relevant to this case, but where they were married and how much is in Zachary's trust account is not relevant. So what I was asking the court what I was attempting to provide to the court is the context that these questions have come after harassment since 2017 by Zachary Cruz. So we are very leery of the of Broward County's intentions as well as the coordination with Augusta County. They have no problem sitting for a deposition. They have answered questions related to what they know about the shooting, what they know about Nikolas Cruz. All of Richard Moore's conversations with Nikolas Cruz are recorded. The state has that. Richard Moore has readily admitted that he has a criminal record. He has asked the state to provide that criminal record so he can give the details that the state essentially already has. But I just want the court to understand that this is not happening in a vacuum. Zachary Cruz has been harassed since 2017, and the questions that were purported to be for this hearing had absolutely nothing to do with why we're here today. So again, we don't have any problems answering the questions. We can provide them in written form so the court can determine the relevance. We can offer that the court provide a magistrate judge to sit in on the depositions. But the bottom line is we want the court to understand that we feel this is continued harassment by Broward County, and it is tantamount to witness tampering. The state knows what Zachary Cruz's testimony is going to be, and essentially it's going to be the fact that it appears that Broward County ignored all of the signs leading up to the shooting with regard to Nikolas Cruz.
That's going to be your client's testimony?
Some of it, yes.
Well, that is interesting because I've already ruled that that's not admissible. So I'm not sure where you're getting that information from. But third-party negligence has already been ruled to be not admissible in this case. So I think that you might be perhaps confused on the issues or why your client is being listed as a witness or why the state feels that they need to get into some of these areas. Is there anything else?
Your Honor, just that again, we feel that this is continued harassment. Certainly Zachary Cruz has a number of other things that could be offered to the jury, maybe not necessarily regarding the third-party negligence, but it certainly, could be surmised by a jury that that's part of the situation. So again, we have no problems answering the questions with regard to the criminal record of Richard Moore. He simply asked for a copy of it so that he can verify his record and not fall into a perjury trap. But we do want the court to know that we feel that this is continuing harassment. We're also asking the court to investigate based on all of the information it has, and ask the Florida Department of Law Enforcement to investigate.
Investigate what?
Your Honor, as I indicated before, we feel that this is tantamount to witness tampering.
Asking a witness questions like, have you ever been arrested? Are you married? Where do you live? I read both the depositions in full last night and highlighted. You're saying there's continued harassment that would warrant the Florida Department of Law Enforcement getting involved? That's
Absolutely.
a big accusation, which if you feel that's the case, then you, ma'am, by all means, should be contacting the police yourself to report this incident.
Your Honor,
rather than wait and put it on me in court. That's not my job. But if you're a citizen and you're traveling to Florida and you represent a client that perhaps lived in Florida at one time, if you think a crime's been committed, then by all means you should report that. To come to court and ask me to, I guess, impanel a grand jury and open up an FDLE investigation into what I believe are entirely appropriate questions that were asked at deposition, that seems a bit far-fetched.
Your Honor, I can tell the court that we have reported this to a law enforcement agency and FBI in Virginia, not here in Broward County, but again, the types of questions that are being asked are completely irrelevant to this sentencing here today. But again, that is our contention, and how much money Zachary Cruz has in his trust account, that's one of the questions of many that we feel are extremely irrelevant and constitute harassment.
I disagree. We've had hearings on the finances of the defendant, probably 2-3 days of evidentiary hearings to determine whether or not he qualifies for a public defender. That issue could conceivably come up at another time or on appeal, and there were documents that were given to me early on in the case showing that the two young men shared bank accounts with their mother. So those questions are entirely relevant, and even if they're not admissible at trial, they could lead to other relevant information.
Your Honor, and I do understand the finance of Nikolas Cruz. Zachary Cruz, we've advised the state that his accounts are separate. So we don't feel that they would be relevant. But again, we don't mind sitting. We would ask the court to appoint a magistrate in order to monitor to make sure that the questions are appropriate from the state, or we would ask the court to allow us to submit the answers in writing so that the court can review the relevancy of the responses.
Okay, State, is there anything else?
I would just again point out to the court that the court has already indicated, the court has read the depositions, the questions were all relevant. Counsel, it's amazing the counsel comes in here today and makes this argument when she could have come in here months ago and made that argument under Florida Rule of Civil Procedure 1.310D. She never bothered to come in until today to make the argument. All those questions were relevant and they were based on facts that could possibly be biased or whatever the state needed to find out from the two witnesses, and I've asked the court to grant the state's motion to compel.
Your Honor, just in response to that, we were hoping that the state would abandon the motion to compel. They have not, which is why we were here, but we were not going to preempt their opportunity to abandon this request.
Okay, based upon my review of the evidence, the depositions as well as the arguments of counsel, I do find that all of the questions that were asked to deponent Zachary Cruz and deponent Richard Moore were not only appropriate, but questions that may lead to relevant information pertaining to this case. I find that the questions were asked in a regular, methodical manner. There was no harassment or any kind of malfeasance that I could read based upon the way the questions were asked and the sensitivity in which many of them were asked when it came to the subject of the deponent's deceased mother. Based upon that, I am going to grant the state's motion. I am going to order that both deponents appear for deposition, that they answer each and every question that are posed by the state unless there is a question of privilege. I did not see any allegation that the questions were not being answered because of some type of privilege. Counsel, I don't know if you're aware of this, but in Florida, when a person is served with a state subpoena, that comes with use immunity, and they cannot be prosecuted for anything that they say other than a lie. So,
Your Honor, in response, they can be prosecuted federally. So that they can be prosecuted by the federal agents or by Augusta. So I understand what you're saying with regard to Florida, but they can be prosecuted federally. So that's...
well, as far as I know, there's no Florida or federal law that says that if you've been arrested for a crime and you admit that in a deposition, that you can later be prosecuted for that.
He asked about the use of marijuana. Use of marijuana is still illegal federally. So I objected to that question because I didn't want Zachary to answer that question. So that's an example of where that is coming from.
Counsel, the feds are not going to prosecute somebody for admitting in a deposition that they used marijuana. First of all, being under the influence of marijuana. And there was a distinction. It wasn't smoking marijuana, it was under the influence of marijuana. That's not a crime.
Zachary has been through a lot. He's been through a lot that we would not have expected him to be through. So he was, again, hauled into a grand jury in Virginia to ask questions about a Florida case. So I'm not entirely confident that the FBI is not going to use those questions against him, even if it's about marijuana. He had $500,000 bond on a trespass. So again, respectfully, I'm just letting the court know that there are some issues federally.
Okay, well, he's going to answer all of the questions. If he doesn't, the remedy is going to be that I'm going to strike his testimony. Like I said, I have reviewed all of the questions that were asked by the state. They were all relevant, appropriate questions, and under Florida law, both of the deponents are required to answer. If you want to certify a question, that's fine, but the deponent still needs to answer the question, and then you can bring it before me. However, instructing a deponent not to answer a question is inappropriate, and it is not legal under the Florida rules of procedure, unless there's a privilege, and there was no privilege that was claimed. So that's my ruling.
Understood, Your Honor.
All right.
They will comply.
Thank you, Judge.
Your Honor,